Good afternoon. My name is Conner Clemons. I am the attorney at our Pasadena office for Cunningham Legal, the estate planning attorney at this office. I practice estate planning and trust law. I only practice estate planning and trust law. So we would like to thank Mr. Jim Helms and Sterling Myers for letting us continue their practice, letting us inherit their customers, their clients, if you will, so that we have the ability to continue what they've started to push forward. The estate plans they've worked with, we have all their estate plans on file, and we appreciate the opportunity to work with all of you. So how I'd like to start this presentation today is really talking about how to keep your estate plan current, how to keep it up to date. There are some changes in estate planning laws and tax laws, as well as industry standards that I'm going to discuss today. We're going to talk a little bit about trust administration, and we're going to talk about how we help families when they go through the loss of a loved one, how we help give them a little bit of guidance and a little bit of protection. I'm going to start the presentation talking about the background of Cunningham Legal. I'm going to talk about the locations and our staff members, the history of this firm. We're going to talk about estate planning, an overview, trust administration, and finally, we might mention a few financial planning mistakes that people make throughout the years. But first, I would like to give you my disclaimer. Everything we talk about today, it is for educational purposes only. I hope it's for your entertainment purposes as well, but I can't promise anything. It's certainly not legal advice. Now, after today's presentation, I am going to welcome anyone who's a Helms & Myers client to come into our law firm for a complimentary review. At that time, that is legal advice, but today it is for your educational purposes only. So our firm was founded by Jim Cunningham. Jim, he is an attorney. He started this firm in 2005. He wrote a best-selling book on estate planning called Savvy Estate Planning. You can purchase it on Amazon.com. It's a really easy read. Jim grew up in Southern California. He lives now between both Southern California and Northern California. He primarily practices out of our Auburn, California office. That's where our headquarters is. Jim, he is a certified specialist in estate planning and trust law, just like how Jim Helms was a certified specialist in estate planning and trust law. Now, we have 9 attorneys in our office, 2 of which are certified specialists, and 2 of which have advanced degrees in estate planning and taxation. So I have an advanced degree in taxation. That's my focus within this firm. I have my master's in taxation from Loyola Law School. If you're looking at the pictures of us, I am the only male on the bottom column. And that's really my specialty. I do estate planning. Above me on the pictures is Liz Seitz. She is second to the right on the top column. She's the other attorney at our Pasadena office. So if you come in to meet us or come in for a consultation or for trust administration, almost certainly you're going to be working with one of the 2 of us, me or Liz Seitz. We have 8 offices throughout California, 5 of which are down here in Southern California, Pasadena, Woodland Hills, Huntington Beach, Westlake Village, Camarillo. Now, obviously, Pasadena is the one where most Helms clients are going to end up, but we have access to all the Helms & Myers files throughout all of our offices. So if it's more convenient for you or your successor to come to one of our offices, we can certainly get your file there and service your beneficiaries, your trustee there. Now, when I talk about estate planning, a lot of people, what they think of is documents, living trust, a will, a power of attorney, healthcare documents. But you know, at this firm, really, we've realized that it's not the documents that make the estate plan go. It's really the preparation, the thought, the attention to detail that makes estate plans work. So I'll give you an example of what I'm talking about. A lot of people, when they think of estate planning, they think of death. We think of both incapacity and death. So I had a client earlier this year, and she came into my office and she put her portfolio down on my desk and we reviewed it. This client, she came with her daughter that lived in Pasadena. And the first thing I noticed was in her estate plan, she had her son as her successor trustee, her son who lives in North Carolina. Now, I asked this client, why do you have your son as successor trustee? And she told me, well, one day I will die and my son from North Carolina, he will fly here to Pasadena and he will sell my house and he'll split the assets among my children 3 ways, just like that. And I said, well, that sounds like a great plan, but what happens if you become incapacitated before then? What happens if you develop dementia? And she told me, well, obviously my daughter, obviously she would be the one that pays my bills, takes care of the finances. But her estate plan wasn't written that way. Her estate plan had her son as successor trustee for all situations. So we restated her trust. We made it so that her daughter was her successor trustee in the event of incapacity, and her son was her trustee in the event of death, having 2 separate trustees for both situations. Now, all that being said, it's important to fund your trust. That's probably the most common mistake. You have to pay attention to make sure your assets are aligned with the trust. Anytime I have a review of somebody's estate planning documents, the first thing I ask is your house deeded to your trust? And half the time, my clients tell me, I don't know, my attorney never did that for me, or I refinanced after I did my estate plan. I'm not sure if it's in the trust. Well, if that client died right there, their house, if it's not in the trust, it probably goes to probate. California doesn't care how much money you've spent on the trust. They don't care how many attorneys have seen your trust. If your house, if your bank accounts are not in the trust when you die, they go to probate. Now, I might have clients listening to me right now who think, I don't need to put my bank accounts in the trust. I have my kids as beneficiaries on the trust. Well, our most frustrated clients, they are the people who can't access their parents' bank accounts if their parents are incapacitated. So when you put your kids as beneficiaries on the accounts you have, that works just fine if you pass away, if you die. But if you are incapacitated, the trustee can only manage what's inside the trust. And if bank accounts are not inside the trust, if they're just in your name and have kids as beneficiaries, they will not be able to be accessed without a conservatorship. And you probably started this whole estate planning process to avoid conservatorship. So make sure your bank accounts are in the trust. Now with estate planning, everybody has a unique story. Everyone has their own individual issues. And most commonly, the story that is told is the story of probate. So for anyone who's unaware, what probate is it's a court process where a court oversees the distribution of assets from a deceased person to living people. It's an unpopular process, particularly in California, particularly in LA County, because it's a long process. Your average probate takes about 20 months, and it's an expensive process. For $1 million probate, $1 million estate, and I don't mean $1 million in the bank, I'm talking about the value of your house. No debt included. If you have a house worth $1 million, you have $1 million estate to the eyes of California. The $1 million probate fee, it's all set in the probate code, is $47,900. So about 1/20th of all the money you have, assuming you have no debt, goes to probate fees. And that's not where these death costs stop. Your children, you'll have to hire a real estate agent to sell your house. They'll have to hire accountants to show the beneficiaries that everything was done correctly, to show the IRS how the gain was calculated. They'll be responsible for paying for property tax as these months go on during the probate. So it's a really unpopular thing for that reason. Now, how do you prevent probate? Well, you start a living trust. So the way a trust works, everyone describes it differently. Let's say it's like creating a fake person. So I'm going to start my own trust. I am the grantor over my trust, and I fund my trust while I live. I put my house in my trust. I literally deed my house to my trust. I put my bank accounts in my trust. I put my brokerage account in the trust. How about retirement accounts? Do you put a retirement account in a trust? No, you do not. That is a trick question. We will talk about retirement accounts a little bit later, but retirement accounts, they stay out. Your stuff is really automatically in your trust. And you manage it. You manage it as long as you are alive and as long as you are healthy. You are the trustee of your trust as long as you are alive and healthy. That means you're the human representative of the trust. You manage it, but you name a successor trustee as well. You name a successor trustee for incapacity, and you name a successor trustee in the event of death. You are the beneficiary of your trust for your whole life, whether you're healthy or whether you're not healthy. All the money in the trust goes to you. Now, one day you might become incapacitated, and at that time you have a successor trustee. Maybe it's your child, maybe it's your friend or a company. They manage your assets for you as the beneficiary. They pay for your healthcare needs. They pay for your housing needs. And then one day you die. And at that time, your trustee has instructions. And their instructions are to distribute your money to your beneficiaries. And even though you're deceased, the trust in the eyes of the law is still living. And that money is distributed from your trust that's still living to your beneficiaries. And that's how probate is avoided. Now, I keep talking about this concept of trustee, successor trustee. How do you pick a good trustee? Well, for most people, you want to pick somebody you can trust. Who would have thought? Children are an obvious choice for successor trustee. You want somebody who's competent. Proximity matters as well. It's probably not a great idea to have your son in North Carolina as your successor trustee if you're going to need somebody to get your mail. Now, I have clients all the time who say, I have 3 trustworthy, competent kids, and they all live on the same street in Arcadia. Well, if you're in that situation, it's probably best to pick your child who's best at communication. Our trust administration department, they would tell you that communication is the most important factor when it comes to a successful trust administration. Someone who can let beneficiaries know what's going on, help everyone calm down, exactly that, the tough stuff that happens when somebody dies. Now, not everyone has somebody who can act as trustee. So a lot of our clients, they name a fiduciary to act as their trustee. Obviously, the fiduciary is paid, but it is a job to be a trustee, and that makes sense for a lot of folks. Do you have a trust protector? So a trust protector is a really important element to estate planning. There are laws that change frequently with estate planning. What I mean by that is at some point in the future, after you sign your estate plan, something might change, maybe a small change in law, and you might not address it. You might not update your estate plan before you die or become incapacitated. Well, when you have a trust protector, they can change the trust, these small parts of the trust, to make it current with the law. So the majority of Cunningham Legal clients, most of our clients, they name us as trust protector over their trust. So if the laws change after they sign their trust, we have the ability to update the trust. And probably more importantly, we have the ability to change things like names of the trust. So imagine we have a client whose daughter is successor trustee and beneficiary, and her name is Katie Smith. But after her parents sign the trust, she gets married and her name becomes Katie Jones. And her parents die. Well, back in the old days, we would have to go to court to figure out how to change her name, to get instructions, to change her name, to keep the trust current. But now a trust protector, they can come in and they can update the name without having to go to court. Now, a trust protector also plays a big role in asset protection. So asset protection, for years, people have been coming to estate planning attorneys, and they have been asking attorneys, how do I protect my child's inheritance from divorce? And for years, attorneys have said the same thing. When your child inherits money, make sure they put it in a separate bank account away from their spouse. But I will tell you what, that is easier said than done. I can only imagine if my parents passed away and I inherited $500,000 and I took my money and I told my wife, this money's mine, I'm going to go put it in a separate bank account and I'm not going to give you any access. We're not going to spend it on the family and I'm going to name the kids as beneficiaries. That would be a bad day for me. Really tough. And even if I was able to get away with it, if I ever did go through a divorce, my spouse, she's an attorney. She would make the argument that I'm sitting on this $500,000 inheritance and she's entitled to spousal support. So we don't prefer to leave money to beneficiaries anymore. Even though we can keep money separate property, the money's still being used to influence a divorce. So the way we like to leave money is to continuing trusts. So several different continuing trusts I'm going to talk about here. The first one is called an inheritance protection trust. So this is Judy you're looking at. Judy, she is successful. She's a doctor. She's in a risky marriage. So risky marriage, your parents see that one coming. Being a doctor is great, but you always run the risk of medical malpractice. And her parents know that. Her parents are leaving her $500,000. And the way they're going to leave it to her is through what's called this inheritance protection trust. It's a continuing trust, separate from the revocable trust. It's built in the trust her parents started, and it operates a lot like a bank account. Now, Judy is the trustee over this trust, and she is also the beneficiary on this trust. So she can go to the bank and she can pull out her $500,000 and she can go buy a house. Or she can pull out $10,000 and she can go to Europe. But whatever money that Judy leaves in this trust, it is provided asset protection. So let me explain this. Let's say that Judy knows that she's going to go through a divorce. She sees it coming, or she knows she's going to get sued. Well, she can call Cunningham Legal and she can say, I am about to go through a lawsuit. I can't be trustee over my trust. And Cunningham Legal, as trust protector, we can remove her as trustee and we can name somebody else, a fiduciary, her financial advisor, her friends, anyone really besides her family. And when that lawsuit starts, she's provided asset protection. If Judy were to go to the bank and say, hey, show me the account balance on my inheritance, she's not trustee. She has no access to the accounts. If her spouse in her divorce says, let's see the trust, I want to see how it's written. Why can't they distribute money to you? Well, the trust says all distributions are totally discretionary to the trustee. So the money, it stays put in the divorce. And once the divorce is over, the trust protector makes Judy trustee again, and she can use the money as she wishes. Now, this inheritance protection trust, this is one of the most popular features at Cunningham Legal, this combined with the trust protector, but this is not the only continuing trust that we use. We also use what's called a DOLE-IT-OUT trust. A DOLE-IT-OUT trust doesn't make sense for everyone, but it certainly has its place. So we have Chris here. Chris doesn't make a lot of money. His wife doesn't make a lot of money. And because of that, they've never had the opportunity to manage a lot of money. And his parents are going to leave him $500,000. They know that if he were to receive $500,000 all at one time, he would probably spend that money pretty quickly on a boat or a car or something that depreciates. So what his parents have done is they've left Chris's inheritance in a special type of trust where it's managed by a trustee besides Chris, and the money is distributed slowly, maybe at $3,000 a month or $5,000 a month. Something where Chris has some money to spend, but if he blows through his $3,000 for the month, it's not the worst thing in the world because he'll receive another check the next month for $3,000. And hopefully he will learn some money management skills during this whole process. The principal that's in the trust, that continues to grow over time, which can be effective. And most importantly, this trust has better asset protection than the inheritance protection trust. Because Chris, he's never trustee. He doesn't need to go to a trust protector if he's going to get divorced. If he gets divorced, if he gets sued or something like that, he has automatic asset protection. All distributions are discretionary to the trustee. Now, the final continuing trust is called a special needs trust. You might have heard of the special needs trust before. They've been around for quite some time. Now, a lot of our clients, their children receive means-tested benefits like Medi-Cal. And when you receive Medi-Cal, you can't have over $2,000 in your bank account at any one time. So when our clients, when they want to leave their kids on special needs kids $500,000, they would lose that Medi-Cal. They left them $5,000, they'd lose the Medi-Cal. So the way these clients structure their inheritance is through a special needs trust. Now, this is a special continuing trust where the beneficiary does not act as trustee. Somebody else acts as trustee, a family member or a fiduciary, and money is paid out directly from the trust to pay for the child's needs. And that could be housing needs, that could be food, that could be a vacation, it could be a concert, something besides cash so that the child doesn't lose their Medi-Cal or their SSDI. And it is highly effective, and it's almost necessary if the beneficiary is on means-tested benefits. And that is the special needs trust, and it really does a lot for people. 70 to 80% of our clients, of our really people, they face disability at some point in their life. Are your estate planning documents current, the ones besides the trust? Now, the durable power of attorney. What this does is it allows a successor to manage your financial situation for you if you cannot speak for yourself, if you are unable to do so. Now, powers of attorney, they've evolved quite a bit in the last 10 years for Medi-Cal planning purposes. Now, you might have heard of this before. This is a really trendy area within estate planning. But a lot of people, they would like to qualify for Medi-Cal one day without having to relinquish control of all their assets or spend down their assets. So I'll give you an example of what I'm talking about. I had a client just a few weeks ago. He inherited a brokerage account a few years ago, and it was worth $1 million at the time. Now, this client, he has a house, he has a small checking account, so really his big asset is that brokerage. And he has medical needs. He's surviving on oxygen, he survives at home, he has 24/7 in-home care, and he spends a lot on that in-home care, and it comes out of that brokerage account. The brokerage account that was worth $1 million a few years ago is worth just under $400,000 today. And he is tired of it. He wants to leave that account to his children. Well, we were able to use his current power of attorney to reposition his estate. We were able to gift that brokerage account to what's called a Medi-Cal trust. Now, this is a special type of trust where the government, Medi-Cal, they don't consider what's in it as an asset. So like I said, we put the brokerage account in the Medi-Cal trust as well as the house. So he's able to qualify for Medi-Cal, so his nurses are paid for. But at the same time, he's still able to control where the asset goes once he dies. He's still able to direct it to his children. And almost just as importantly, he has such little control that the government, the IRS, gives his children a step up in basis once he passes away. The kids still get a step up in basis so they can liquidate the brokerage account when he dies and have no capital gains. And this was all possible because he kept his power of attorney current. You know, there are a lot of attorneys right now making a living off of Medi-Cal planning. So it is important to make sure your power of attorney is current and allows your successor to make these decisions for you. Do you have the correct healthcare documents? Do you have an advanced healthcare directive? An advanced healthcare directive allows your successor to make healthcare decisions for you if you cannot speak for yourself, if you can't give informed consent, whatever that healthcare directive agent says goes. Do you have a HIPAA on file? A HIPAA allows medical professionals to access your medical records if they need to, particularly people who are not your family member. Now, doctors, they take this very seriously. Healthcare service agents, they take this seriously. A lot of HIPAAs, they have expirations on them, so it's important to make sure yours are current. HIPAA laws didn't exist until the late 90s, so if you did your estate plan, before 2000, you have to make sure you have a HIPAA. Otherwise, your healthcare documents, they won't go very far. Do you have a physician's order for life-sustaining treatment? That is really a DNR, a PULST. that is a legally binding order, like a DNR, that says don't give you CPR if you are incapacitated, if you have a heart attack. Now, I'll be quite honest with you. If you're using the computer to listen to our presentation right now, I don't think you need a pulse directive. What I think you need is a living will. A living will is non-legally binding orders to your successor as to how to treat you if you cannot speak for yourself. Whether you want tubes if you're incapacitated, whether you would like antibiotics if you are incapacitated, all of these things. It's important to keep these current. These laws change, and they make a big difference at the end of somebody's life. Now, I assume everyone here has IRAs or 401ks. So for this presentation, this part of the presentation, I am going to refer to all these accounts as IRAs. Now, this is going to be new to probably all of you because I know Jim Helms, he didn't do this type of work with IRAs. So IRAs, let's assume that you are 59 and a half or older and you pull money out of your IRA. What happens? Well, you pay taxes. Easy, right? You pay taxes on that distribution, ordinary income. What happens when you turn 70 and a half? Well, the required minimum distribution, RMD, the government forces you to pull money out of your bank account, or excuse me, out of your IRA, and they force you to pay taxes on it. It is a very bittersweet moment in an older person's life, but that is the rule nonetheless. So you pass away and you're married and you leave your IRA to your spouse. Well, the IRA then, it can be rolled over and the money is taken very slowly, the exact same way you were taking it. It's not really a big deal for tax purposes. But what happens if you're a widow or if you're single? What happens if you leave your IRA to your children? Well, what are their choices? Well, really, they have two choices, and the majority of children, they make the same choice. And that choice is to take all their money at once. So what do I mean by that? Well, let's assume you've left $500,000 in an IRA to your son, and he takes his money all at once, $500,000. Well, that's all going to be income for that year. $500,000 from the IRA, plus the money he makes at work, the money his spouse makes at work. He'll probably be in the highest tax bracket for that year. Does anyone know what the highest tax bracket is if you combine federal and California rates? 50.3%. So in this situation, 50.3% is going to go over the majority of this IRA is going to go to the government. That is not the ideal situation, but this is what most people do. The better way to take money is through an IRA trust. So let me explain how this works. You take a stretch out over time. So it's based on age. Someone inherits an IRA and they take it as slowly as possible. Okay, so if you inherit it when you're 50, you have 35 years to take the money. Now you have to take out money every single year. You take it slowly, and the remaining principal continues to grow tax-free. So if you have an IRA or you have a 401k, you know how powerful this is. You know how powerful tax-deferred growth is. Imagine tacking an extra 20 or 30 years onto the growth that you've already seen in your IRA. It can do a lot of damage. So imagine passing your IRA to a grandchild. So if you look at our chart here, this chart, it shows what happens if you pass $100,000 through an IRA to a particular beneficiary, and the beneficiary takes their money as slowly as possible. So let's say you've left $100,000 to your grandchild, who's 30 years old when you pass away. Now, let's assume the grandchild averages 6% a year returns, which is pretty fair. Now, the current laws, they allow the child to take the money over 55 years until they're 85 years old. So over the next 55 years, that $100,000 is going to turn to $700,000. Now, I know some of you get better returns than 6%, and that's called compounding. You can see here what happens if you get an 8% return. It turns into $1.5 million over 55 years. Or if you get a 10% return, it turns into $3 million. So this is a really effective way to pass on a lot of money. This is done through what's called an IRA legacy trust. So we go back to it. Why do these Americans, why do they choose to take that money all at once? Well, a lot of them, they don't make that choice. Some of them do out of greed, or they just do in a big rush. But a lot of people, they take the money all at once because they didn't act. If you don't make an election of how to inherit this money by September after your parent has passed away, you take the money all at once, which is really unfair, but that's the way the rules are. So people do these IRA legacy trusts. So they elect the stretch out before they even die. They take the money as slowly as legally possible before they die. It takes the pressure off the beneficiaries. So here we have another example. So Rosie, she leaves her $200,000 IRA to her 30-year-old son, Tom. Tom, he gets his $200,000 and he pays off his mortgage, very responsible, pays it all off. But his tax bill, it's still going to be about half of the IRA distribution, and maybe 40%. So he's going to pay $80,000 to $100,000 in taxes, which is unfair, but that's the way it is. Now with an IRA trust, Tom, he takes the money slowly. He's able to take it over the next 55 years until he's 85. And with $200,000, if he has normal S&P 500 returns for the next 55 years, knock on wood, we hope that's the case, he will receive about $6 million over that time. $6 million. That's how effective compounding is. To add another 55 years, tax-free growth to your $200,000 IRA, that is quite effective. Now, I will say not everyone who does these IRA trusts, they don't necessarily do it just to build assets. They do it to keep money in their family. So let's assume you name your daughter as beneficiary on your IRA. And let's assume she takes it the correct way. She takes it as slowly as possible, but then she dies. Well, we live in a community property state. So your daughter in this situation, she's going to have named her husband as her successor, her beneficiary. She's going to be essentially forced to. And that money's going to go to him, And that's not what most of my clients want. What most of my clients want is if their child passed away with money still left in this IRA, they would want it to go to their children, to stay in the family. And that's what these IRA trusts allow. They allow our clients to name a contingent beneficiary in case their child either predeceases them, or if there's money left in the IRA, which happens all the time when the child passes away. The money stays in the family, it goes to the grandchildren, it's managed by the trustee until the grandchildren turn a certain age, but it doesn't go to the in-laws. And that alone is a big enough reason to do an IRA trust. IRA trusts don't make sense for every client we have, but they certainly have a place in estate planning. Now, I know there are a lot of folks out there who might have an AB trust. You've probably heard of an AB trust before. They were the industry standard in the 90s and 2000s when the estate tax exemption was much lower. It was $600,000 per person back then. So what we did when we had a married couple, estate planning attorneys, to preserve these exemptions, what we would do is we would fund a B trust upon the death of the first spouse. We would put $600,000 in a B trust and keep it estate tax-free, death tax-free. So that was the only way back then to preserve the exemption. But splitting like that was really, honestly, a pain. You have to allocate $600,000 to a B trust. That could be a house, especially back then. You have to file a separate tax return on whatever's inside the B trust. So that's 2 tax returns a year, as if one wasn't a headache already. And whatever went in the B trust, once the surviving spouse died, nothing in there got a step up in basis when it passed to the children. So it was an inconvenient time. Today, our estate tax exemption is no longer $600,000 per person. It is now $11.4 million per person, $22.8 million for a couple in 2019. So extremely high, and as you can imagine, it affects very few people. And more importantly, the IRS in 2011, they said, all this splitting business, putting assets in 2 trusts, we don't have to do that anymore. As long as the surviving spouse files an estate tax return when the first spouse dies, and as long as they don't remarry, they get to have the first spouse's exemption. So these days, this whole splitting business in an AB trust, it's almost totally obsolete. Now, every once in a while, we have clients who die with this AB trust in place, and we go to court to terminate the B trust. We go to court, literally, and ask permission from a judge to do so. And as you can imagine, that is an extremely expensive process, but it is easier than living with a B trust. I will tell you that. When you do a B trust, that splitting alone costs a lot of money, and it's important to get rid of the B trust if you have one in place in most situations. So we go to this next slide, and we see that the documents, that's just the core of the estate plan. Really, you need to make sure that you're tracking the life changes in between. You know, there are changes in the law that we all pay attention to, but I'll tell you what, make sure that you keep up. Now, some of our clients, these ones who have these AB trusts, the ones who we have to go to court for to get rid of the B trust, they could have prevented that had they reviewed their trust before the first spouse passed away. Now, we offer a program called the Legacy Care Program where we track our clients' assets. We track their situation. We track their family. We give them a family meeting every single year, and we ensure their estate plan is set up the correct way. People who are below the age of 70, maybe early 70s, I encourage you to review your estate plan probably every 5 years, to at least make a phone call to our office, to at least make sure you've spoke to an attorney about whether there have been any law changes. Once you're over that age of 75, once you're in your 80s and definitely in your 90s, it's important to revisit your estate plan probably every year or two to make sure you are current, because anything at that time, everything becomes a lot more real. So we go back to those 3 stages: documents, incapacity, everything in between. It's not just the documents that make this go, it's the preparation, the real thought in these estate plans. Now, I see people all the time in this office who come in here with a real idealized version of how their life is going to be when they die. They have this perfect scenario set up where everybody gets along and everything's perfect. Now, our job is to really bring you back to practicality, to realism, to prepare for what's really going to happen, to make sure that the estate plan is funded correctly, to make sure that everything is done as well as it can be done. Now, we go on to incapacity and death. And it's unclear to people, you know, what happens when somebody dies and you prepared your whole life for incapacity and death, but it's kind of confusing at that time. What happens? Well, you know what? Things need to be done. Now, not everyone needs a lot done, but everyone needs something done. You at least need some guidance, and you oftentimes need protection. So what that's called is trust administration. Now, whenever somebody dies, whether it's a Cunningham Legal client or a Helms and Myers client, we encourage them to call our office. Anyone who goes through this situation, they call our office, and we will provide a complimentary phone consultation to anyone who's lost a loved one, where we can go over your situation and talk about what needs to be done. And sometimes these estate plans, these situations can be complex, but there's always something there. Proposition 13. That is extremely valuable in families, especially when somebody dies. To preserve a low property tax base is priceless. Capital gains is an issue too. We have to make sure that houses get appraised. We have to send out notices to the correct people to make sure that they can't contest the trust. Trustees are liable to the beneficiaries if there's not enough communication, if things aren't followed correctly. It's important that these directions are followed. It's important that the wishes of our clients are carried out, and we are there to guide our clients through that process, through trust administration. If anyone ever loses a loved one, your successor trustees, make sure they know they can call our office and they can get a complimentary phone call. So that is really it. Now, I do want to wrap up, and I want all of you to know that we are here for you. You're not just clients off the street. You are Helms and Myers clients, and now really you are our clients. You call us, we will have your file on hand. We have it stored off-site, and we can order it, and you can come meet with one of our attorneys. We give a complimentary review, and that's what I'd like to offer you at this time, to call in to our Pasadena office or whatever office you feel comfortable calling, and to schedule a free complimentary consultation so we can take a look at your situation, so you can meet us, so you can see our office, see how you feel. I'd like to meet all of you in all honesty. And so far, my interaction with Helms and Myers clients has been great. Really intelligent group of people. Very impressive compared to some of the people I see out there. And if you have any questions, if you want to make sure that everything's up to date, come in for a free consultation. If you have changes, or if I think you have changes, I will give you a quote. It's always going to be flat fee, and the decision from there is yours. So I'd like to thank you for taking the time to sit down and listen to me today.